Carl Munson here, and a delight for me to be talking to Daniel Reis of Reis Pellicano. And we had a wonderful webinar last Thursday, Daniel, where we were talking about Casa Portuguesa. And in the part of the webinar where people could ask questions outside the recording, we had a very interesting conversation about leases for accommodation here in Portugal. And it was some great stuff, but sadly it wasn't recorded. So here we are, because we must share this with people. The leasing situation is very different here in Portugal compared to the United States, correct, I would say. So let's talk about that this morning. Before we do, of course, can we hear a little bit about you for people who haven't met you yet? You are Daniel Reis, of course, from Reis Pellicano. Tell us a little bit about the legal practice there in Lisbon, if you will.
Well, our law firm is composed of professionals that, well, we mainly target our audience to foreign nationals. So the majority of our clients, I would say 95% of our clients, are foreign nationals, and a good bulk out of them are US, UK, South African nationals. So we do have a good and interesting mix of clients, and we do target our public to foreign nationals. The main bulk of our work, I would say, is comprised of property acquisitions, golden visas, Portuguese nationality, some tax law as well, and problems connected with people living in Portugal. And rental agreements, as you said, is one of them, and one of the major sources of work as well that we have here in the country. So we do face, I would say, almost on a daily basis, questions, problems, occurrences connected with rental agreements. And indeed, it is a preoccupation of our clients, because I would say the normal trajectory out of a client that comes to Portugal out of an expat is that you will search a property abroad, you will find something, and you will move with that rental agreement. Usually a rental agreement that is properly reviewed and that is assessed will avoid having problems in the future for sure. But even though a good rental agreement will not avoid problems that can occur afterwards, namely the one that we were mentioning, noise-connected problems that the building may have, or other disturbances that may occur. And this is where things usually get a little bit more complicated, because if you are paying for a property, you are entitled to rest and not to be disturbed by your neighbors that are practicing the drums. So those are situations that we usually try to resolve peacefully without going to courts, because one of the things that we did mention is that the court system in Portugal is quite slow. Therefore, trying to resolve things in a peaceful manner, in a way that, although it might not be the greatest agreement ever, but a good agreement is always better than going to court, or a bad agreement is always better than going to court, let us say.
Okay, so very important to get the right rental agreement in place. And I noticed with the terminology there, you prefer using the term rental agreement in Portugal over and above lease. Is that right?
Yeah, this is, I would say, the normal practice that we use here, rental agreement, because it's the translation from Portuguese to English, but a lease would be exactly the same thing in terms of the terminology.
Okay, and of course, it is a key part of the D7 visa, which many of the people who you're dealing with, who Expats Portugal are dealing with, that is their trajectory, that is their path into Portugal, the D7 visa, and of course, it forms part of other visa requirements as well. And so it's important that we talk about that this morning, the rental agreement. And one of the interesting things, certainly a differentiator from the United States, I would say, certainly from my native UK, is that the rental agreement is lodged with Finanças. Now, this has some benefits, of course. It is a requirement, and it does have benefits. What would they be?
Well, it is a legal requirement, and this needs to be fulfilled by the property owner. So it's not the tenant that has the legal obligation of registering the contract, but the property owner. This is something that the property owner will need to do once the contract is signed. He should go within 30 months or 30 days, I'm sorry, after the rental agreement is signed. He should go to the tax authorities, should register the contract and pay the stamp duty. Usually the stamp duty is 10% of a rent. So if we're talking about a rent that is 1K, the payment of this stamp duty will be 100 euros. With this registration of the contract, the landlord will issue the receipts once he receives the money from the rents. And this is a system that protects both parties at the same time, because if the landlord wants to use the court system to evict, you will need to have his contract registered. So evictions can only occur if you have a rental agreement properly registered. Otherwise, this may be considered tax evasion, and the landlord will be in serious trouble with the Portuguese tax authorities. And the other aspect out of it is that the tenant has a proof that he indeed paid the rent. So once a receipt is issued from the property owner, this means that the landlord is acknowledging that he received the rent, and thus the tenant is not owing any money anymore. So it does protect both parties. And especially here in Portugal, once you're dealing with D7, CEF, and other public authorities, they are now verifying if the contract is registered. So if you need to request a D7 visa, the contract needs to be registered. If you need to go to CEF and do the renewals of your residency permits, they will verify always if the contract is registered. And I would say with other public authorities, the same reality does apply. If they get in touch with the rental agreement, they will eventually request the proof of registration. So this is something that I would say necessary. And this is usually the first step in terms of the negotiation with the landlord, is to request, or not to request, but to ask if the contract is being registered or not. It is a legal obligation, but some people try to slip it under the table and not register the contract and receive the money without issuing the due receipts. And this is a preoccupation, especially if you're a foreign national that needs the contract registered to have something as simple as a residency permit.
Yes, a legal requirement then. And whilst it might seem attractive, if somebody says to you, look, if you pay me in cash, it will be less than the declared amount. That is not a good situation to be in. Is a legal requirement from the taxation point of view, but it's also a legal requirement from CEF's point of view, right? That you have a registered rental agreement of this kind. Correct. And long gone are the days where you could show a few months in an Airbnb or have some sort of cash agreement with a landlord. So make sure you get that right. Casa Portuguesa, of course, is a way of getting that right. And when people work with Casa Portuguesa, of which you are a part, the rental agreement can be translated so that the end user, the tenant, can see exactly what's going on. And you're doing all the due diligence, or Casa Portuguesa are doing all the due diligence for the tenant to be here in Portugal, which brings with it, of course, a great deal of peace of mind. Now, one of the things that came up the other evening was the notice of termination. And it was, what do I do? I'm coming. Casa Portuguesa have found us a fantastic rental agreement. We're coming to the end of our first year. Do we need to send a nice letter to our landlord saying, yes, we'd love to stay? We found out, didn't we, that no, you just carry on as you are. You don't need to give any notice to stay.
That's basically it. Usually, the majority of the contracts in Portugal do have an automatic renewal clause. And this means that if none of the parties wishes to terminate the contract, and the termination of the contract needs to follow specific rules in terms of deadlines. So if the landlord doesn't send a letter to the tenant stating that he wishes to terminate the contract, or vice versa, if the tenant doesn't send a letter to the landlord stating that the contract should be considered terminated upon 120 days notice, this indeed means that the contract will be automatically renewed. If nothing is stated in the contract, basically let's have the following situation: that the contract was stated that it should be for only 1 year, and no automatic renewal clause is inserted in the contract, even though the contract will be considered automatically renewed by the due effect of the law. So it may not be inserted in the contract, but the automatic renewal of rental agreements is something inserted in the law and operates by the passing of time. So if no one says anything, the contract will be considered renewed. And as long as the tenant keeps paying the rent, everything will work as it's been working in the past year. So no need to worry from the tenant's side. Keep paying the rents as the contract will be considered valid.
Okay, and should it be terminated or should notice be given, it is 120 days that a landlord is required to give. Is that correct?
Well, that is, it actually does depend on the duration of the contract. So for contracts that had the duration above a year, the tenant needs to provide 120 days notice. Usually if it's below a year, it's 60 days notice. But one thing is for granted. Usually the duration of the contract will need to elapse at least a third of the initial duration of the contract, so the tenant can send the notice to terminate the contract. And on top of this, you need to have 120 days on top of it. So let's have the configuration of a year contract, the typical in Portugal at the current moment. You need to elapse or to have elapsed a third of the contract. And once this has occurred, you can then send a notification stating that the contract will be considered terminated in 120 days. The landlord has not this possibility of terminating the contract on this short notice as the tenant has. So for the landlord, he has the opportunity just before, or not just before, but usually 120 days before the contract is about to be renewed, he should send a letter to the tenant stating that he will not renew the contract and the property should be handed over. So basically the unilateral termination of the contract can only occur by the tenant, and the landlord and the tenant can oppose to the renewal of the contract. So the tenant has indeed more rights than the landlord, because usually tenants use the properties to inhabit, so for their own habitation. And if you have a property for your own habitation, you should have a superior protection compared to other types of rental agreements.
Okay, and so let's just go in deeper with this from the point of view of a tenant coming to Portugal for the first time to start their new life here. And it may be, of course, their first property is like their base camp, really. It's not going to be their forever home, their dream home, but it's obviously needed for the visa requirements, and they've got to have a place to live and start their life here in Portugal. Now, should they find themselves in a place where that they're not entirely happy with, it served the purposes of getting the visa, but it's not where they want to be, and they would like to move to a different part of the country or a different part of the city. Can you take us step by step through the process of how they need to approach the landlord and how soon they can do it?
Well, usually it's the soft approach is the one advisable. So a phone call stating that, well, I'm now living in Lisbon, but I want to move to Coimbra. Will it be possible on your side to negotiate the termination of the contract sooner than what is expected? If they have, if they're open to it, then an agreement meeting halfway, or just delivering the property sooner and having 1 or 2 months of rent and penalty may be an option. So soft approach always is the one that should be used first, and negotiate with the landlord. As the rental market is heated up at the current moment, I would say that the landlord will find someone to replace the tenants easily. But nonetheless, they will probably need to pay commissions to the realtors, and they will need to spend some money or time to find new tenants. So even though the market is substantially heated up, the landlord, with the termination sooner than it was expecting from that contract, will have to spend time or money to find new tenants. So this, in some way, will need to be compensated, because if a contract is celebrated as signed with the duration of 1 year, then at least the landlord is accounting to have those tenants over there for a year. So soft approach always the one recommended. in terms of the not so soft approach, the one that is in the law and that the tenants have the right to do. So it's a third of the initial duration of the contract that you need to elapse. Then you should send a letter. Usually the notice is 120 days. So basically the initial third plus 120 days, and the contract will terminate on the month that the letter, or 4 months after the letter being received. So and then you hand over the keys. You see if or the property owner should inspect the property to see if any repairs are in need, if the property is being handed over in the same state that it was received. If nothing is broken down in the property, they will repay the deposit, and then the tenant can move somewhere else. But usually what ends up occurring is that unless you're quite lucky, you will have the contracts overlapping. As at least 1 or 2 months, this is usually the norm, and you will need to pay rent in double. So timing is of the essence, but it's quite difficult to time it well so you don't pay double the rent once you're renting. That's almost impossible, I would say. Not impossible, but substantially difficult.
Okay, and so take from that then that with the soft approach and with goodwill involved, you could make a fairly easy transfer from the apartment you no longer want, or the city you no longer want to be in. But
Correct.
Legally speaking, the quickest you're probably going to be able to get out of a tenancy, a rental agreement, is 4 months from the time of serving your notice.
Well, yes, if the initial third of the contract has already elapsed. So
Yeah.
This actually depends on if this third of the contract has elapsed. So for a contract of a year, a third is 4 months plus 3 months. You can get away minimum with 7 months. That's the minimum ballpark that you will. 120 days is 4 months, so it's 8 months in total. It's 4 plus 4. And your minimum 8 months in a contract, and then you can hand over the keys and proceed to the new rental.
Excellent. I'm glad we cleared that up. So legally, technically, that your minimum time is 7 months, but that would exclude the goodwill scenario.
No,
beg your pardon, 8 months.
It's 8 months. Yeah,
8 months. But apart from that, if in a soft approach, as you say, you may be able to reassign a lease with the goodwill of the landlord involved. Excellent. Just quickly then on the payments when it comes to rental agreements and leases. And using this 1 year most common scenario, most people are likely to be paying up front 3 months, aren't they? Their first month, their last month,
Correct.
and their deposit month, right? Is there anything else to say on that?
What people will need to perceive is that in Portugal, you're paying the rent in advance. So in January, you're paying the rent of February, and so on and so forth. So you're not paying the rent of the month that you're using, you're paying the rent of the next month. So when you take possession out of a property, they usually use 1 month as a deposit. So if anything is broken in the property, if anything needs to be repaired, that deposit will be retained by the landlord to sustain those expenses. But if the expense is above that, the landlord is entitled to request more money to pay for the repairs that are needed in the property. So do be aware that the deposit, if it doesn't cover the full amount of the things that were broken in the property, further money can be requested from the landlord to the tenant. And then the 2 months that you're paying in advance is basically the months that you're settling in and the next month. Because let's have a scenario that you rent the house on the 1st of January. You pay 3 months or you pay 3 rents, let's say, 1 deposit and then 2 rents. It's going to be the rent of January and the rent of February. But in February, you'll need to pay a rent again, and you're paying the rent of March. And that's why you pay 2 rents plus 1 deposit. And at the end of the contract, what this means is that you usually don't pay the last rent of the contract because you already paid the rent corresponding to that month, because you're paying 1 rent in advance. But so it's a clever way of putting first month and last month, but in reality, you're paying January and February, or are you paying the 2 months once you take possession out of the property? Because if the contract is terminated sooner, then the accounting needs to be done properly. And I would say that the legal way of doing that or perceiving that is that in Portugal, you're paying always one rent in advance.
Yep. Okay. And best case scenario is that you live in your apartment or you built your house rent free for the last month because you've already paid it. Correct. Notwithstanding any deductions that might be made according to the deposit. So be careful with that. It's not over till it's over, right?
Correct. And usually there's a perception that the deposit can be used to pay the last rent. So sometimes clients will approach me and say, well, I don't need to pay the 2 last rents, correct? And I say, no. You can get away with not paying the last rent because you're paying the rent in advance, but the deposit should be kept by the landlord so he can inspect the property, see if everything is correct, and then he will return the money back to you. But this, of course, can be negotiated, and if the tenant and the landlord are in good terms, the solutions can be found. But the legal solution, what is in the Portuguese Civil Code, is that once or the contract will end, the property will be inspected at the time that you hand over the possession to the landlord. So usually our recommendation is that the tenant should be there at the same time that the landlord is taking possession out of the property. The landlord should inspect the property, and eventually, if something is broken down, the report on what was broken down, what was found that will eventually need to be repaired. The landlord then should do the repairs himself or hire someone to do the repairs and deliver the invoices to the tenant to prove what was repaired, and then deduct those expenses from the deposit. Things like or things that usually break down by the passage of time. These are things that, unless the tenant broke something acted without the due diligence that he should. So if it's just something that broke down with the passage of time, let's have a quick example, like a wooden chair that the glue, because of the passing of time, just simply broke away and the chairs are now wobbly. Well, I wouldn't say that this is a repair that the tenant should need to support. But if on the other side you have clear markings on the chair that the tenant was knocking with a hammer on the chair, then this is a different scenario. So some good sense should be used, but indeed, if it's something that breaks down by the simple passing of time, like for instance yellow walls, this is something that paint will get yellow with the passing of time, but this is not a fault of the tenant. But for instance, if he is a hard smoker, this will be debated. You see, so some common sense should be applied, but this is the rule of thumb.
So wear and tear, basically, is what we're talking about, should not be charged for. But this is an interesting situation, Daniel, because who decides ultimately? And this might be where it's very useful to have somebody like Casa Portuguesa in the mix who can negotiate on your behalf, because there is no third-party advocate or judge on this, is there? This will be between the two parties of the landlord and the tenant. So it could be useful to have your agent, someone like Casa Portuguesa, in there saying, no, come on, this isn't how it should work, and doing that on your behalf.
Yeah, that's indeed a reality. But if the parties are not able to agree on a solution, well, the only third party is the court. So but usually for minor situations like this, a disagreement of 300, 400, 500 euros, or even 100 euros, it doesn't compensate to go to court. So depends a bit on how substantial is the money that is being requested from the landlord, and what is the deposit provided on the property. This does vary quite substantially, so only on a case basis can that be assessed.
And of course, it should be borne in mind that it's the landlord who already has the money, right? They're paying you back the deposit. It's not as if, right? Okay, so they have the advantage in that respect.
But,
okay.
But that's the importance of having the inspection of the property with the landlord, and that report produced by the two parties at the time of the delivery of the property. Because if you just hand over the keys and the landlord will state, well, I'll check the property in 1 or 2 days, don't worry about it. And then he checks the property and states that everything is just simply broken down in the property. Well, it's a bit difficult to fight this back. So a report done on the day of the handing over of the property and a proper inspection done by the landlord.
Do you think a video, you know, just with your phone, if you went around the property with the landlord, the owner of the property, and did a visual report, would that suffice? Would that be a useful benchmark?
Well, it's good to have a video report out of the property done, indeed. But at the end of the day, having the document signed by the landlord stating that the property was handed over in the correct state would be the desired situation. Because otherwise, there's always room to hearsay and that the property was not handed over in the correct state, or that the video didn't cover this room, that the floorboarding is all up. So I would eventually have this document produced by the landlord stating that the property was handed over properly and that no repairs are needed, or if there are repairs needed, what are the repairs composed of. And then at least you know the ballpark of the expense that you'll have and how much is going to be roughly the deduction made from the deposit, if any, of course.
Okay, and the emphasis is on the landlord to get this report made, is that right?
Correct. The emphasis is that the landlord, because he is the one that has the money on his hands, so having him signing a document stating that no repairs are needed in the property will waive the possibility of him retaining any money considering the deposit.
Very good. Okay. Now we're in a situation, of course, where we have immigrants and foreigners, expats coming towards Portugal, and sometimes with the way that the whole lease requirement, the rental agreement requirement has worked out, their property might be empty for some months, many months before they even arrive here.
Correct.
And some of them are thinking, I know, I could let this out to another person in my sort of situation. That must go through people's minds. Is that workable, doable, and advisable even, Daniel?
Well, I would say in the full majority of the cases, no, because in the majority of the contracts, you'll have a clause stating that you don't have the possibility of subletting the property. And if you are subletting the property, you will eventually be in breach of the contract and thus cause of termination of the contract by the landlord. So I would strongly discourage it and not advise going down that route. Eventually, if this is inserted in the contract, but the majority of the landlords will not wish to have this inserted in contracts. But if by any chance this is a provision in the contract, then yes, you are entitled to subletting the property. If this is not written specifically in your contract, then no, this is not an option, because you will be in risk and peril of having the contract revoked and reaching Portugal without a property to live.
Interesting. Yeah, you could put yourself in a much less advantageous position, thinking that you were indeed making some money in the first instance. But again, it's the soft. If you're to do this at all, it must be done legally, and maybe,
correct,
as you said before, with the soft approach of talking to the landlord. Look, you know, this place is going to be empty for this many months. Can we come to some sort of arrangement? And that would be the way to approach it, right? Rather than do it secretly or separately, out of sight of the landlord.
If this is discussed at the time of the negotiation of the contract, then by all means you can do it. If this is a situation that evolves after the initial signature of the contract, eventually an addendum to the contract may be done, and the landlord will accept the subletting of the property. So the initial people that are renting the property will not lose as much as they're losing for just having a vacant property. So indeed, as long as the landlord knows and authorizes it, if it's in the beginning, perfect. If it's halfway in the duration of the contract, all good as well.
Okay, well, that's really good to know. I think that we've pretty much covered most of the basics, I think, of taking out a rental agreement, certainly for the purposes of the D7 and what people might expect on arrival here in their new home, literally in their new home apartment and in their new home country. Is there anything we should add? Anything I've missed there, Daniel?
Well, I should state that, again, at the current moment, there's not a lot of properties vacant to be rented, and that's why some landlords are imposing their own rules that sometimes may not be according to the law. So searching for professional advice is something that we do strongly recommend, and a well-written contract does avoid a lot of problems in the future. Some problems will not be avoidable, but indeed preparation is key once you're moving countries, and if you're renting a property at a distance, do search for professional advice. That's my advice.
On all fronts, of course. So from finding the property, do get involved with Casa Portuguesa, who will, where you are, send them your requirements. If you're in a far-flung land and not here in Portugal yet and not able to visit, they'll take care of that for you and meet your needs. And they'll be able to tell when they hear a little bit of something that's not quite right in a possible rental or even a purchase that you may not be aware of as a non-native Portuguese person. And then when it comes to the legal part of it, certainly work with Daniel here of Reis Pellicano, who you can find in our business directory. Daniel, it's been so good to talk to you, always is, and I look forward to talking to you again sometime soon.
Well, thank you, Carl. My connection today is not facilitating this, but thank you again for calling me for this. I love it as usual. So that's it, I think.
Thank you very much.